of my photography there. I took a little bit of time out over lunch, and obviously they're all in copyright because I took them. I actually own the copyright of these photographs, so I thought I'd use them to demonstrate where we are. My background, okay, so I'm an academic lecturer in intellectual property law in Lancaster University Law School, but I started to do a little bit of work with a few more sort of creative SME supporting networks. And I've got a strong link to the Create Centre, which is a UK-financed research centre at the University of Glasgow as well. And that looks into projects which try to predict how technology will change and develop and how businesses can actually respond to, well, the growth of the internet and the need to protect creative ideas. Okay? I know obviously what I'm going to talk about here is intellectual property rights and law, but I'm not going to go into a great deal of detail. You all come from different backgrounds. You will all have your own specific IP issues to deal with. I'm just going to give you a general overview and then try to link the framework back towards SMEs and just talk about a few of the research projects that are ongoing in the UK. A little bit of an example just to talk about, go back here, in relation to creative industries and IP. When I was working with one of the partners through the Create network, we have a documentary filmmaker. And they were making documentaries and creating their businesses and distributing these online. They did a short documentary about teaching, okay, teaching in a primary school classroom. As the camera swung around the classroom, there was a television in the corner, and that was playing an episode of The Simpsons. Okay, so there was a few stills of The Simpsons that were picked up. When they were packaging this and we were talking about the IPR rights, there was a highlight point made about, well, actually, do you have the authorization to show this? Okay. And of course, I got in touch with The Simpsons lawyers, Matt Groening's team, which you can see would be very kind of cash rich, as it were. And they said, yes, well, you can show this, but it will cost you $15,000. Okay, so $15,000 to have the actual screen just go past The Simpsons, playing in your documentary. And that shows some of the tensions in relation to IP rights and SMEs. Of course, you want to protect your product. Now, you want to be able to commercially exploit what you're doing, but you also want to build upon the creative ideas of others and ensure that you're not infringing yourselves. And again, in this technologically enhanced world, quite a few of you will have infringed upon IPR rights, copyrights already this morning. Okay? You've got your smartphones, you've got your laptops. There will be issues that you have encountered online which will mean that you're already infringing. And this is going to be where I kind of focus on later on, and it's to do with education and enforcement in relation to these IP rights. The next thing I want to say, and it kind of pulls back into Martin's talk earlier on, is that I teach IT law with a focus on IP to undergraduates and postgraduates. I use interactive technology quite a lot, so the students can give responses as we're talking. And I've got to tell you, in a class of 110, approximately 20-year-olds, right, about 98% of them had not bought a CD in the last 5 years. Okay? They are not spending their money on CDs because they are downloading. This is a huge issue in relation to the creative industries. And then also, when you get them to talk about some of the kind of more moral issues behind this, a lot of them don't think that what they're doing is wrong as well. So we have this kind of growing generational normalization of infringements in relation to copyrights. That's just a few of the things that I want to highlight in relation to achieving a balance. Okay, I'm sure you know all of this. So we're looking at transnational collaboration. I mean, going back to the 1880s, there's been international collaboration, okay, in relation to IP rights. You've got the Paris Convention, the Berne Convention, both developed around the 1880s. Okay, so this has been an issue that has been ongoing, yes, for centuries, in fact. We've got the World Intellectual Property Organization and TRIPS. Now, they help manage IP rights and try to find some global harmonization, as it were. And I've got to say at this point, what we're really looking at is harmonization of standards. It's only later when we start to talk about the unitary patent, which is a new development, that we actually look at a situation in which the same patent law can actually be applied in different countries, in different member states. I'll talk to you about that later. Okay, so what are we looking at? There's a need to integrate the initiatives and develop these cohesive strategies. What's happening increasingly is that policymakers and lawmakers are realizing that they create this framework and actually it's not functioning. It's not actually fulfilling the purpose that it should. And there's been a strong focus on, as I say, these soft measures, these regulatory measures, educational measures, training and support, particularly for SMEs, in relation to managing their IPR. Okay. Really quickly, I know that you'll know all of this, and each individual industry will have its different issues, its different problems. Patent law, it is a high-level monopoly that is granted, but it's limited. Okay, so you know this. So you actually get your patent, and you have a monopoly over this actual inventive product or inventive system, as it were, because you have fulfilled strict requirements. And that is the payoff. And I know I come from this academic perspective. I don't want to talk too much about the theoretical perspectives here, but it's a kind of contract theory that you get in relation to a patent. So for disclosing information, the consideration or the payback you get is this high-level protection. So you give something, you get the high-level protection back. Why is it good for society? This is what I want you to be thinking throughout this, because what's good for society should be good for creative industries and SMEs as well. It's because although you cannot commercially exploit the information that's there, you can work on it. Yeah, you can look at this, you can actually understand how this inventive product was created, and that's now in the public domain. So that's the payoff. Okay? There's a kind of term I'm going to use a little bit later on, and I don't know if you've come across this notion of patent trolls, as it were. Okay, these are the companies which actually will patent new inventions and, to put it in a sense, and just sit on them, not work them, not use them. Now, obviously, when research has been done, it is the bigger companies that are able to do this, and they're doing it in a way which thwarts innovation and creativity in some of the lower, smaller organisations as well. So talk about patent trolls a little bit later on. Trademarks, of course, this is one way of branding your goods, distinguishing them, and there's a certain level of harmonisation at a European level. Okay, in relation to this, let's go really quickly through this. Copyright. Now, one of the key issues with copyright is there's no need to register. Our trademarks and our patents, you need to register. And with patents, you need to go through a substantial amount of paperwork. I don't know if you've actually been part of a team that has put something to patent. And in the UK, the average amount of time is 3 to 4 years it takes to have a patent granted. Now, that again is one of the issues that is stopping development and thwarting creativity there. Okay, so copyright, you create something, you're sat at the back perhaps, and you think of a great new song, you write this short story, immediately you have the economic rights in that. And one of the issues with copyright, the key kind of power of copyright is that it's transferable. Okay, so you can then license it, you can give other people powers to use the copyright in your work. In the UK system, coming from the European system, there's also a level of moral rights as well. We now have a protection whereby you've got a right to be acknowledged as the author and a right to object to any derogatory treatment of that work. Again, this has had to be developed in relation to trying to find a balance between commercial entrepreneurs who want to exploit and license and transfer rights and the actual initial creator. Because if you're going to invest money in a company that actually licenses, transfers and sells on creative works, at some point you don't want the author coming back and actually asserting rights which significantly affect the contracts that you have developed. Okay, so that's the balance that needs to be achieved there. Big disadvantage is the impact of the internet in relation to copyright, and that's why we've got a strong focus on creative industries. Now, again, sort of links back to what Martin was talking about before. With the music industry, they were very, very slow to adopt business models to address the infringing downloads. Okay. They now seem to have moved further into, obviously, your kind of Spotify or your iTunes, a model in which people might pay. But we have a generation of users who are not used to paying any money for their creative content, as it were, and they're used to sharing. Even slower has seemed to be the kind of broadcasting industries and the TV creators and the film creators who are now giving services where you stream. So you've seen your Love Film, your Netflix, these kind of things. But again, there's no real area in which it's very easy to own yeah, to pay for and own these downloads, okay, that you're actually spending money on. Whereas if you know where to go, you can get these for free. Okay. We have the Digital Economy Act to address this, but there's been, in the UK, sorry, the UK has a Digital Economy Act, but there's been quite a lot of stalling in relation to actually creating a code under which this will function. And internet service providers have also brought a few judicial reviews, because I don't know if you're in the e-commerce area, they're used to having this concept that comes from the US of safe harbor. So as long as they're not actually involved in the information that's being transmitted, they're normally exempt from liability. What the global approach to copyright law infringement in relation to what's happening with the internet has found as a focus is that the ISPs are the conduit. They're the links between the person at home downloading, yeah, and the company whose works are being infringed. So they're being focused upon. So what they're trying to argue is that they're having liabilities that they shouldn't have had in the past, that they're being called upon to actually act and respond. Digital Economy Act in the UK, basically, if you're a downloader, you could get 3 letters from your ISP and you would be cut off. Yeah, that's the approach that's being taken. But obviously ISPs, these service providers, are having to get involved, and they're used to just standing back, yeah, and taking the money from people who pay for their services. That's been one of the focuses there. Okay. And again, law of confidence. This might be one of the areas that you use in order to interact with potential suppliers, distributors, and it can be built into a contract as well. But one of the key drawbacks here is that actually, if the information that you're communicating gets into the public domain by a third party who's acting in good faith, then that defeats your rights. So there's always this kind of threat of, well, we have somebody who's contractually bound in order to keep our work and development secret. However, if somehow this becomes in the public domain and someone in good faith allows it to be spread, then you have no legal redress there. And what I was thinking about with drawing this back into Valerie's talk in relation to marketing as well, and this seems to be, I don't know if you've got any example, seems to be one of the key issues in relation to small and medium enterprises marketing, because if you disclose too much in your material at too early a stage, that can defeat a later patent as well. So disclosure actually defeats the criterion of novelty in patent law. So you want people to know about your product. If they know too much about it at a later stage legally, then you could have a problem. You could be looking at someone trying to revoke your patent. So again, it's finding that balance. Now, I've just given you a really quick run through of some of the key issues here. And as I say, I'm coming from a legal background, but what I'm seeing in the research is smaller companies saying, okay, IP exists, but it does not help us. It does not support us. We're not actually engaging with the legal framework, the judicial methods of protection. And the other side, the softer measures, are these kind of factorial issues. So it's protecting it by protecting your IP by having a strategy that's inbuilt into how you deal with other businesses, rather than actually paying the money to get the legal expertise in. And you see it increasingly in the research. I'm really going to sort of quickly pull you through. Is that what's coming out of the sector, small medium enterprise sector, is that information's wanted, quick, targeted information, but information that's also not expensive as well. And we see from the research is quite a lot of businesses are just choosing not to engage with the protection of their IPRs and just to give things a go, okay, because of the mess of the framework that we have. I mean, to be honest, the law is quite straightforward. It's how it's applied. It's the enforcement and the ability to get good advice, yeah, where the issues lie. And again, this notion that SMEs are often the ones that change things, that actually look at areas, look at different sectors, and bring about new and innovative concepts. Trying to be quite quick on here, but obviously I'm coming from an academic background, but what I want to kind of get you to think about is the actual rationale for IP law in the first place. Why protect? And there are, pardon?
Sorry, many of the SMEs that I work with decide that they're not going to pursue an IP protection route because it's too difficult.
Yes.
And as you say, the protection is payoff for disclosure.
Mm-hmm.
They don't want to disclose. They'd far rather just go early to market, get the sales, and then deal with the consequences when somebody reverse engineers their product.
Exactly, yeah.
Often they say if you disclose the people, they know they have the recipe.
Mm-hmm.
So I don't want them to have the recipe. So I just keep the secret and I just go on the market.
There's a reason why Coca-Cola don't patent their formula. Okay, they keep it secret. That's one of the big examples of that, yes.
And another thing is you have to defend your IP.
Yep.
So if you don't have the money to pay the lawyer, you don't have to have an IP. So this is why we see the same thing that a lot of SMEs don't.
Yeah, exactly. They're the key issues that come up in the research that I'll go through. What we're seeing is quite a lot of, talk about member states, countries. I'll very quickly introduce what's happening in the UK as far as from a policy perspective. They're trying to address the legal framework in a way in which it does support innovation with a key focus on SMEs as well. And I'll show you some of the UK Intellectual Property Office reports. And what they're also trying to do is to look at the entire framework and just to bring it back to its theoretical underpinning. Because basically there are a number of different reasons why IP is actually protected. We've got intellectual creations, intangibles that are protected in a legal level using kind of quasi-property rights. It's almost, it's akin to the protection of property. One of the reasons why property rights developed is because property, land, goods, is a finite resource. Finite resource. Human creativity is actually not a finite resource. That's one of the wider arguments in relation to addressing the kind of hub of the framework and changing things. The other thing is there's this notion of kind of moral law, natural law. You create something, you want to be rewarded for it. Okay? That seems to be one of the underpinnings of the framework. And then we've got the kind of, with John Locke, labour theory approach. You've worked on something, again, you should actually receive some kind of reward for what you've done. The other theory that actually underpins the development of a lot of these frameworks is that protecting IP fosters innovation and creativity. And this just seems to be accepted. And it has been accepted by policymakers, by legislators. And in fact, there's no real strong empirical research that says that. If I were to talk to you about IP issues, I'm quite sure that some of you might be saying, well, actually, the protection of IP has been a strong headache, a real headache for us. And it's been very difficult to be creative because of, A, the difficulty of enforcing the laws, but B, the fact that the bigger companies, the ones with the money, are much more likely to be able to use the legal framework. And again, this is again what the Create Centre is trying to look at, developing some empirical research projects to say, well, does this framework actually improve creativity, innovation, develop society forward? Or are we actually stifling innovation in this way?
But maybe that then depends on the very objective of the SME. Because, I mean, if you are going to want to collaborate and want maybe to innovate together, and you have actually to protect what is your part that you have brought to this collaborative project. I mean, you have to go through the process, otherwise, I mean, it's not possible. But if you're just an SME who's not really wanting maybe to collaborate or to build on this innovation to make another innovation, I think then you maybe don't have to. And then maybe it depends on the final objective where you want to go.
Not just depends on the final objective, and also different sectors have different needs. And again, this has been one of the discussions at a policy level to say, well, should there actually be different IP frameworks for example, biotech industries, software industries, because we do have this legal framework that has developed and hit the new technology, and perhaps there needs to be some changes there as well. Okay, so SMEs are less likely to enforce. What have I got here now? This is just a real, really quick run through of some research in the area. And this is what I was finding fascinating when I was kind of looking at some of these. The notion of the strategic non-user of legal protection. So building into the business plan the notion, the idea that you know that there will be IP issues, but you're having to just address these as you go on, and you're not bringing in professional legal advice at any point. what some of these more kind of government-based research projects are doing is having recommendations. And again, one of the key recommendations, this was a larger research project over the EU, was this creation of horizontal networks of SMEs, exactly the type of thing that we're developing today, to get people together to talk about the problems, okay, to talk about the issues, to share information. Well, that's kind of a notion of knowledge exchange as well. Streamlining of advice. Yeah. Again, where do you go for this information? Talk about it a little bit later on, but a big UK report is finding from SMEs that there's been some bad advice given. Okay? There's a large amount of litigation in the area of IP law. Now, the Legal Services Act will actually regulate lawyers, expensive lawyers, who can give you advice. If you go outside of this, then you might be in danger of getting advice that is not correct and doesn't actually support your business. Now, we're doing a big legal education training review, and one of the particular recommendations is to have sort of paralegals, non-fully trained lawyers who just actually focus on SMEs and intellectual property rights as well, and they're trained in that way. So instead of doing their qualification certificates in order to become the lawyer and charge a great amount of money, you've then got a regulated group of individuals who are the IP advisors for the small, medium enterprises as well. So that's one of the recommendations coming out of government reports there. One thing I want to talk to you about, it's really quite quickly, and again I promised I wouldn't go into the law in too great a detail, is the unitary patent. Don't know if you've heard about this. Now obviously I've just stood here and said there's a need to make the choice as to when to engage with these intellectual property rights. But if you were to, this is seen to be a development which hopefully will support SMEs in Europe. Now, when I went through and talked about, right at the beginning here, we had the WIPO, and there's also a European harmonised patent. What would happen with those is that there'd be an umbrella group, so the WIPO, okay, at an international level. And that would help you to get your patent. But what you then have to do is choose the countries in which you wanted to enforce it and still fulfill the regulations and stipulations of their laws. So can you see, you're not just getting one patent that will then apply in a number of different countries. What you had to do was, with the community patent, you had to say, well, actually, these are the countries in which I want this to apply. The unitary patent is going to be different. Now, it's going to be, you actually patent your inventive process, and this will then apply in, not the 27 member states, but 25. Italy and Spain have not signed up to this, and there's a key reason, and it might kind of ring true in here, and it's the language issue. Just think about this. Patent law, it involves technical specifications, technical disclosure, and the three languages of the unitary patent will be French, German, and English. Spain and Italy said that this, as far as the translation requirements go, this was not acceptable and have not signed up to the unitary patent at all. So, in 25 member states. So you register, and this patent can then be enforced in the 25 member states who are part of the scheme, okay, who aren't Italy and Spain. And this gives you protection, across Europe for your patent. No need to then go into the different member states and to fulfill their laws. So again, hopefully, this will allow for development and change. But one of the criticism is, and this notion of intellectual property tourism. So what happens is, with a unitary patent, you actually you develop your patent in one of the member states. And one of the potential for this, one of the drawbacks might be that you go to the member state with the friendliest patent law in order to get your protection. And then this applies throughout the 25 member states. So that's been one of the criticisms of this new unitary patent. That might be something that happens. So again, there is harmonization over Europe in relation to standards, but it's not fully harmonized yet.
Excuse me?
Yes?
Just a question. What about the cost?
The cost?
Yes. For...
I mean, they haven't actually developed the cost framework yet. It's not, basically, it should come in 2014. But they're saying it would be equivalent to the cost that it would be to be in a member state. So we're looking about sort of €2,000, perhaps. Quite low. They're trying to keep the cost low.
What about the States, the United States,
Basically, when you look at the information in the US and Japan, it probably costs about, on average, about 3 to 5 times more, in fact less, sorry, to patent an invention in the US and Japan than it does in Europe. Yeah, the costs are high, and this is what the unitary patent's trying to do, is to bring the cost down and to make it easier to enforce. Yeah. Just really quickly, you get a grant of a European patent, and then you can take on another step, yeah, in order to get the unitary patent. And the actual paperwork and requirements, it's all on the WIPO website there. Okay, I'll just pull through some of these. It's the kind of things we've been talking about. SMEs are more likely to rely upon the soft measures, the lead time advantages as well. But obviously that can be problematic if there's a need, for example, for safety testing, if you're in that kind of area. So you have your lead time advantage that it's undermined by the need to safety test something, and then competitors come in and actually benefit from the time you've taken, you know, to safety test something, to safety test your product. Okay, lots of different studies as well, coming out with the same kind of things. SMEs make use of the patent searches, but are not engaging with the actual registration as well. Biotech companies are more likely to have this strategic ongoing framework for quite obvious reasons there. This is one of the key issues, again, when we look at recommendations, this notion of trolling. Now, patent trolling seems to be something that the companies with the bigger amount of resources it's a practice that they can actually undertake. So remember, this is buying up the patents so others can't use them. So it goes against this notion of promoting innovation, creativity, yeah, from the legal framework. And I know it seems quite obvious, but SMEs are much less likely to do this. Yeah? But then, obviously, they're in a position whereby they're going to be impacted upon by larger companies doing this, yeah, in a marketplace. Some of the statistics, they're more likely to be sued than to sue. And again, you know why? It's this access to justice issue, isn't it? So it's the amount of time and the money it takes in order to enforce these rights. But this is a new development we've seen in the research in the past sort of 5–10 years of using IPR rights in order to package your business. To say, well, OK, we have protected this patent at a certain level, and this is then part of our plan to make you look like a company that should attract investment as well. And this seems to be a phenomenon that's growing. Okay.
And what you said before, for example, it's really, really important. Some of the SMEs we work with, for example, they don't patent because this way of doing to block the progress of competitors is quite often impacted by big US companies who are really searching for good patents and block them and try to block them or attack them by lawyers. So there are some firms that have really huge, they lost a lot of money and then they just gave up at a certain time because they can cope with the financial drain of the US company. Yes. So that's really something which is an important frame for the SMEs to patent actually.
Yeah, but this is one, I mean, there's been a wide-scale UK policy report trying to stop this practice of trolling, as it were. And there's some statistics, some things such as that 1 in 10 patents are actually worked. Yeah, quite a lot just go in the bottom drawer, yeah, because they've got the resources to be able to do that. Again, talking about how intellectual property organisations at a governmental level engage with SMEs, there's a need to embed an awareness at all levels. This seems to be what's coming out of the research as well. So not just have somebody at the top of a company who just thinks about these issues, but to have education and the need again for sort of secrecy, disclosure and an awareness of these embedded throughout the company and on an ongoing basis as well. So it's a strategy that's revisited throughout a company's development as well. And then what are we seeing? Our governments trying to help. Now this is one of the US initiatives, sort of online assessment tools. This has come based in the, from the WIPO, and they are in the US developing strategies to help smaller businesses engage with their own IP strategies and actually try to protect what they're doing. And again, through the WIPO, there's a vast amount of resources as well that can be used. Enforcement, remember, it's speed and cost. And from a legal perspective, this is where sort of legal researchers can make changes really. is that in patent litigation, there are a number of different ways in which you can make it more difficult for the other party. You can delay proceedings. You can ask for certain disclosures. And one of the key recommendations is to take away that ability for opponents just to impact upon the costs of the other party. Lowering the risk of frivolous applications, and again, it's only those who have the money who are able to do this, and the cost is what we're talking about over here. Europe has about 3 to 5 times more than that of US and Japan in relation to the cost it takes to patent there. These short quotations come from the Hargreaves report. I'll put up, there's references that will be on the slides. And again, this is the 2011 Wild-Scale Independent Review of IP in the UK. And there's a particular chapter focused on SMEs and their experiences. Too many different services, it's difficult to choose which one. And you can't tell which services are reliable or trustworthy. Now, this is an area in which the government is trying to put in resources to develop, for example, these online tools, and also mediation services as well, coming from the intellectual property officers. Okay? Hargreaves review. The big, broad recommendation in relation to this is the need for accessibility, lower cost, and integrated IP and commercial advice. And again, this pulls back to what I'm talking about with training. So having very particular sort of non-qualified lawyers who know specifically how to deal with IP rights in relation to SMEs, and that again is going to be developed alongside the university sector as well. So we're looking at courses to develop those. Yeah. Okay, that was going to be the interactive bit. Some sources of help. Again, you probably look at these on a daily basis, but there's SME pages at the WIPO website. The European Commission and the European Patent Office have lots of help online for you to be able to access some of these resources. Now, what I've been talking about there is the Hargreaves report. It's fascinating because it's this wide-scale report that was based upon a lot of research that was carried out in the UK. And Ian Hargreaves, and he's at a university in Wales. This was in 2011. In 2006 in the UK, there'd been another report, a large-scale report looking at IP protection, with a focus on SMEs, focus on developing creativity, innovation. The recommendations, around 54 recommendations of this first report, the Gowers report, they were supposed to be implemented by 2008, and about 24 of them were. Okay? So we have these large, objective, independent reports, and then governments not responding. Well, the UK government didn't respond and didn't change the framework in order to address these recommendations. So the Hargreaves report came along, and he's got 10 broad recommendations, hopefully trying to avoid what happened with the Gowers report. But it's a very forward-looking, it's all-encompassing piece of work that tries to, again, support business, but also look at how technology is impacted upon the ability to protect IPRs. And it's a very interesting read to look at. And recently, the UK government has said that it would fulfil one of them already. So that's actually, after a year, one of the recommendations is being acted upon, and there are legislative proposals. And this is to do with developing the defences to copyright law as well. So there are changes that are happening. And again, pulling back to the kind of theoretical underpinnings of the whole system, there is this notion that the system's not working. Right? The law might be clear and acceptable, but it's how it's enforced and the practical link between the law and businesses that needs to be addressed with these soft regulatory measures. Okay, that was quite quick, but I'm going to hand on, quite swift run through. I'm going to hand on to Peter. Okay.
Good morning, everybody. My name is Peter van Donken. Thank you, Doris. Thank you, Phil, for the kind invitation. I'm from the Netherlands, working at the Netherlands Patent Office. I'm working there for approximately some 10 years. Prior to that, I used to work in the industry, both in a corporate situation, a US-based organization in water treatment, and a small startup in the Netherlands. I was asked to talk a little bit about IPR management, but I have a particular emphasis on how universities are doing it. So let me ask you the first question. How many of you do actually work at a university?
In or with?
In or with? around? Or maybe at the technology transfer office of a university? Okay, then that my presentation can be of some use to you. And for the rest of you, I ask you to bear with me till lunch. In the Netherlands, we have depicted 9 what we call top sectors, where industries and universities are forced to work with one another. It is basically a rationale of cutting the deficits in terms of money. Universities are to be seen as a kind of R&D department for the 5 big multinational companies in the Netherlands for the next 5 years. So that is bad news for universities because they will lose again on independent research. And then what you always face is problems with joint IP ownership. Who is the owner? Is it the inventor? Is it the person working at the university, the professor, the PhD student? Or is it in fact the company who is deciding to want to acquire the IP? Obviously, there will be problems with licensing because based on ownership, you can license your IP to third parties. But what's even worse, sub-license it if the first situation is not clear. So within these public-private partnerships, which are enforced upon universities and the big companies in the Netherlands, we are going to face massive problems in the next couple of years. Taking you through some theory. On the left top, you see academia and R&D departments where new technologies and new, let's say, innovations are created. Obviously, the bridge is to get them into the either spin-off companies or existing companies, and maybe you can use IP law or contractual law. And those are arrangements which are tailor-made. There is no blueprint approach for that. It depends from sector, it depends from industry, depends from size of the university. And what we tried now for an industry, and I'll come to that a little bit later, is to explain to students and to researchers how this is working. Because we all start on the left-hand side where a university is embarked on public research. So you would like to think that the research results automatically belong to that university or to that professor. But usually researchers or even professors are not aware of the fact that when they have an employment record with that university, they file away their rights of IP, meaning that all intellectual property automatically belongs to that university, and the university, as is the case with copyright, belongs automatically to the university and not to the individual inventor. And this creates a lot of tension. Okay, now suppose there is some knowledge, know-how, and the university wants to license it out. Then the only way to do it is to see whether that is really research which brings so much new facts and figures that it is patentable. And I receive on a weekly basis what I call Invention Disclosures. So from each university in the Netherlands, I'm working together with approximately 14 universities and 20 research institutes, I receive some 10 what we call pre-filing patent applications, Invention Disclosure formats. So they describe what actually they think is new, which did not exist prior to the research. And based on an invention disclosure, we do a kind of, let's call it a search into, it's not state in the art because that's what you do on a patent application, but we do a search in the patent databases and we see whether there are already existing patents or publications which come pretty close to this invention disclosure, and we bring back that news to the tech transfer office and let them decide whether or not to continue with a business case or the inventor or the professor to start up a new company. So you, in that way, you bring public knowledge to the private domain. And of course, the phrasing secret knowledge is absolutely wrong because, as you might know, all patent publications once become public and also become published 18 months after the filing of a patent application, all the contents of the patents become public knowledge. And you can read them either in a SPASnet or in sources. Now then it's easier to license off your IP. Some more, let's say, research from left to the right. What you see happening is all the phases in the stages bringing fundamental research to the marketplace. And this is a very well, assuming to be straight away arrow, but it's not at all, because obviously companies will also, inside here, will also contract research universities to supply them for new results. But basically the idea is such that if there is an invention coming out of a discovery, and I usually have to distinguish discoveries from inventions, and that is a very hard job to do with researchers. But only inventions can be patented and discoveries cannot. So once we have described it as an invention, then it can be applied in the industry within a company for development, for prototyping, and then it can be brought to the market. Okay, let us go to some research here. This is actually done for a couple of years for approximately 105 universities from all over Europe. From the Netherlands, there were, I think, 9 universities on board. So what they used to do, questionnaires, they checked the Web of Science to see where the publications came from, and they double-checked it with PodStat, which is a tool from WIPO, World Intellectual Property Office. And they looked what happened with the patents in the regional, what they call the regional business environment. And these are the results. So what you can see, the size of a university matters very much when it comes to how able are they to receive contract research from companies. But also, there is a positive association between the size of a university and their patent activity. And it's even more so if you look at a university with an engineering department. It's quite logical. But also, the size of the contract research is very much connected and positively with their spin-off activity. Now we try to do that in the Netherlands as well. And we did it for a period of 10 years. Now here if you're working at a university or a tech transfer office, there are some things which you can influence. Not the mission of the university. That is usually in the statement of a university for 4, 5, 6 years, whatever. But it's strategy, what we used to call nowadays valorization. That is what you can change a little bit. And especially the size of your TTO, because this is a very important discriminator in the whole process. More people you have there, business developers you have there, either patent lawyers you have there. So human capital is the key. That is one of the issues. I can't speak about all the details between all the different universities in the Netherlands because that would take me too far out. But what I'll try to do is to align all these input factors with its output in terms of articles, in terms of patents. And what I found more interesting is to see how these patents eventually create business in terms of startup companies, in terms of new jobs in the Netherlands. So these were the universities who were participating. We used more than those indicators, we used 15. And this was the setup of the research methodology. First of all, based on the names of the universities, we looked into a SPASnet to look into their patent applications. Then I had to go and beg all the human resources departments from the universities, please send me the names of your researchers. Now, can you imagine what a pilgrimage I had to take? It's amazing because it's all a secret. And I was only under sworn oath, I was given the names of the professors and the researchers and the PhDs. So, and then what we did, the names of these persons, they could be potential inventors. So we put the names of those researchers in this tool of PodStat. And we tried to see if there are, and they were, more patents in which personnel from universities are involved in patents than in the patents that came out straight, which are filed in the name of a university. And the results from that, we contra-validated with the database of the university itself. based on that validated university patents, so that is these patents plus the patents we refilled from Padstad, we sent a number of questionnaires to Dutch multinationals, international multinationals, and that was very hard, all the IP and new business development programmers, and to small and medium-sized companies, and to spin-off companies. Now you see, it's not very persuasive, the number of questionnaires we could send, but at least we did an effort, and we also tried to analyze the questionnaires. Okay, these are the results. For 10 years, these are the numbers from the universities, so 10 universities and 4 medical centers in the Netherlands. So on average, 14 per year per university. But if you look into the number of patent applications in which personnel of a university has been involved, it's much higher. And you can say that on average, if you have at your university, you have 1,000 scientists working, 91 patent applications. But there is a large spread, and the spread I'm not able to talk about because that is confidential information, but that depends very much on the policy. And that depends very much on the valorization strategy of the university. Now, we continued with the socio-economic effect by the questionnaires, and this is a general figure. Each university created per year almost, say, 6 to 7 spin-off companies. But on IP-based, so only on patent-based, it only created 2.7 spin-off companies per year. Now, from all the data I received, that in the first year only 1 to 1.5, maybe 2 persons were working in that spin-off company. But it's growing very rapidly. Most of the hours working in that company, in that spin-off company, are dedicated to research and development. And that is, in my opinion, having worked in a big company, but also at a startup company, that is a very wrong idea by itself. You should work with the customers, with the market, because you can do this at the university. You can continue working on your model or your prototype and make it better and better and better, but if there is no customer willing to pay for it, you end up burning cash, money, burning your money, and there's not going to be a market for your company. So that's the end. And that is why most of the spin-off companies in the end fail. Now, we had an estimation that they have a net income of approximately some 40,000 after 5 years. Now, what is interesting is by doing all these questionnaires with different users, multinationals, small and medium-sized enterprises, and spin-off companies, you can also see how these different entities use intellectual property arriving from a university. SMEs and spin-off companies use it for acquisition of funds, and particularly so biotech companies. They use their IP, they use their patents to make a round with venture capitalists. And based on their IP and a proper, say, a good proposition and good management staff, seasoned engineers or seasoned managers, they can acquire substantial funds. I'm talking about millions of euros. But they basically also do it to demonstrate the innovativeness of the company. And in that way they can contract research maybe from other companies. So that is another way of making sure that they have some funds for their work. And in the end, they do it for product development. If you then look how completely opposite to that, multinationals use the IP which they have either bought or they became owner of, have appropriated from the university, it is to be used for the exclusivity against third parties. So a very defensive step. It is to be used to prevent third parties by filing patent applications. So they're the user, nobody else can use it in the marketplace. And maybe they will develop a market, but not a product. Okay, well then it's only logical to assume that if you want to create more companies and if you want to create more jobs, because that is basically what I'm interested in, that you should start in thinking about creating more spin-off companies. And well, I admit the figures and the figures and the facts are not very overwhelming, and we're certainly going to beat the Chinese with these figures. But now I had a discussion I was so late yesterday with my ministry to discuss these facts and figures. Direct employment created by universities, all the universities who were participating in this research, 40 years. Basically, the 2.7 spin-off times the 10 universities times the number of FTE. But the extra is the 30 jobs per year based on license out to SMEs. And if they're going to license out to multinationals, no facts on extra jobs could be measured. So it looks small, 70 per year, but if you take 10 years or you take 20 years, maybe in the longer term, and if you change your policy as a university or as a government, I think this is the only way forward. Impossible to assess. They just wouldn't let us give us the figures. Okay, if you have any questions, feel free to ask me or send me an email. I'll be happy to take it.